Good day and welcome to today's panel discussion on the Compensation for Occupational Injuries and Diseases Act, or COIDA, panel discussion as hosted by the National Employers Association of South Africa, NEASA. The purpose of today's discussion is to highlight and emphasize the following topics. Firstly, a discussion of the dysfunctionality of the fund overall over the decades. We'll also talk about the COIDA Amendment Bill and the consequent build-up to the issuing of the newest COIDA rules, the effect of the new rules on business, specifically employers, injured workers, and third-party administrators. And then we'll also discuss the most recent meeting with the Minister of Employment and Labour, as well as the Compensation Fund Commissioner, regarding the implementation of these new rules. Before we start, let's start with an introduction of today's stakeholders and panelists. Welcome Mr. Jaco Swart, the National Manager of NEASA and the voice of employers in today's discussion. We are joined by Mr. Tim Hughes, the spokesperson of the Injured Workers Action Group, IWAG. We also welcome Mr. Fritz Lüttich, Managing Director of the third-party administrator institution, Compsol. My name is Rona Bakker. I'm the Senior Policy Advisor at NEASA, and I'll be facilitating today's discussion. Let's go to the first topic of discussion today, the dysfunctionality of the compensation fund over the past few years. Mr. Swart, I'm going to address this question with you. What can you tell us about the current dysfunctionality of the compensation fund and what NEASA's own experience as an employer body with the fund has been over the years?
Good morning, Rona. Well, first of all, I think the misadministration and the inefficiency at the fund is well known within the public domain. NEASA has over the years conducted some surveys about its members, and the main takeaway from these surveys is that employers are extremely frustrated with the fund. The fund is inefficient, is corrupt, is simply not working. This obviously has some operational issues for employers. For example, employers can't get letters of good standing, which means they can't tender for projects, they can't get onto sites, which costs them money. Secondly, the fact that medical service providers do not want to treat patients who have been injured on duty as a result of non-payment from the fund creates a cash flow problem for employers, as they need to pick up that bill and then trying to claim it from a fund which is simply not working. From NEASA's own experience, we had an incident where an employee was injured seriously 5 years ago. And NEASA picked up that medical tab. To this day, we still have not been able to finalize that claim. You just get sent from pillar to post. There's no progress. You don't get response. You can't get onto the system. It's an absolute mess.
Thank you very much, Mr. Swart. Despite NEASA's constant addressing of these issues by virtue of newsletters, press releases, and even open letters to the Minister of Employment and Labour, and the Commissioner of the Compensation Fund, can you say that any active steps have been taken from the Department of Employment and Labour side or from the Compensation Fund Commissioner to address these various issues of corruption and dysfunctionality?
Well, I think the short answers to that would be no. The Compensation Commissioner and the Department of Labour and the Minister of Employment and Labour simply did not reply. We had no response from them whatsoever. Scopa on its own started an investigation into the allegations at the fund and the inefficiency at the fund, and that they have taken the Compensation Fund Commissioner and the Minister of Labour to task on this. I also understand the Minister of Employment and Labour has been ordered by Scopa to institute a forensic audit into the fraud and corruption at the fund, and also into the suitability to hold office of the Compensation Commissioner. I believe that process is still ongoing and has not been finalized. So we hope that through our continued campaigning and awareness campaigns, that we will be able to make a difference and bring this issue into the light and get it resolved.
Absolutely, I agree with you, Mr. Swart. Thank you very much for your submission in this regard. The next topic we'd like to discuss is the COIDA Amendment Bill and the consequent build-up to the issuing of the newest COIDA rules. Mr. Hughes, I'd like to pose this question to you. On 17 January 2021, the COIDA Amendment Bill was gazetted and the public was invited to submit their commentary. What were the most prominent amendments to the main act by virtue of this bill, and what would the effect have been of these amendments should they have been passed as legislation?
Good morning, Rona. Thank you very, very much for the opportunity. Thanks to NEASA as well for the unique role that it's playing in this effort to improve the lives of injured workers through the compensation fund. And thank you very much, Jaco, for your intervention. Your question related to the COIDA Amendment Bill that was introduced into Parliament this year. The one welcome element that has happened recently in South Africa is the inclusion of domestic workers under the COIDA. This was through the constitutional challenge, and in essence, the compensation fund was forced to include domestic workers as beneficiaries of the act, of the fund, which itself is going to present problems because of the dysfunctionality of the fund itself. The most controversial, and remains the most controversial part of the act, was section 43.4, and within that section, the law or the bill at the time sought to prevent medical service providers from ceding their claims against the compensation fund to third parties. In other words, if a medical service provider treated a worker who was injured on duty and was able to put in a claim against the fund, this act or this bill attempted to prevent them from actually ceding their claims to pre-funding third parties or entities that had helped them fund or give them cash flow. This produced something like 85 submissions against section 43.4. And I'd like to place on record, there were no submissions in favor of section 43.4. All of them were against. And to this day, we still do not have any justification for 43.4. And eventually, Parliament, through its good work and submissions, removed section 43.4 from the bill and instructed the compensation fund to draft regulations to look at the registration of any entity that wants to deal with the fund. But it removed section 43.4 from the bill.
Thank you very much, Tim. So, just as Tim said now, this clause 43 that was included in the First Amendment Bill prior to Parliament's decision in removing this destructive clause read as follows, and I quote, "Any provision of any agreement existing at the commencement of this Act or concluded thereafter, in terms of which a service provider, which is the medical service providers or the healthcare organizations, cedes or purports to cede or relinquishes or purports to relinquish any rights to medical claim in terms of this Act shall be void." Thereafter, as Tim has now indicated, the Parliamentary Committee amended it and removed this destructive clause, which would have prohibited the cessions of medical claims by the medical service providers to the pre-funders such as Compsol, and we'll address that with Mr. Lüttich in a moment. Thereafter, it's been amended to read, and we place this on record, 43.4a, no third party will be allowed to transact with the compensation fund unless they are registered with the compensation fund in the manner as prescribed. All third parties that are already transacting with the compensation fund must register with the compensation fund within 6 months after the commencement of the Compensation for Occupational Injuries and Diseases Amendment Act. So there we have confirmation of what Tim has just explained to us. Mr. Lüttich, I would like to ask you now, in your capacity as the managing director of one of the preferred third-party administrators in the COIDA claiming process, what would the effect have been on your institution if this controversial clause 43, or the prohibition of cessions of claims, was enacted as provided for in the First Amendment Bill prior to Parliament removing it? What would the effect have been of the First Amendment?
Thank you very much, Anna, for the opportunity to address you. Yes, the effect would have been quite serious, and more so on the medical service providers and the injured workers that we serve. And I'd like to just put on record that there's two parts to our involvement in this process. The one is as administrator, which is we make sure that the claims are processed in a proper manner, that the tariffs are charged as per the gazetted rules and regulations. And then the second phase is the factoring, which happens after the fact. And after the fact of the medical service provider treating the patient, issuing his invoice or his medical bill, and we then look at the bill, make sure it complies, and we will then factor it if it complies fully with what the COIDA Act prescribes. So that's the two parts to it. Now, it's interesting to note that Mr. Mafata's own words is that they have no problem with third-party administrators, but they seem to have a problem with factoring. Now, factoring happens post any billing procedure that happened from the medical service providers. And in that regard, we need to place on record that we will only factor an account if it complies 100% with the regulations and the tariffs. We cannot afford to factor any account that does not comply, as we then understand we won't get paid. Now, factoring in itself is a worldwide acceptable accounting or funding process by which an account that has been issued in the correct format and manner is then factored to assist the medical service providers in their cash flow. So what happens is currently the medical service providers on average waits about 311 days. That's almost a year on average to get paid after they've delivered the service. And it's unreasonable to expect that service providers need to wait this long for the fund to actually process and eventually decide to pay the valid accounts that they've issued and the services that they've rendered. And the SAMA survey that was done quite recently is unequivocally clear that 90% of the service providers that partook in the survey said that they will stop servicing IOD patients because they are not in a position to wait for 311 days on average to get paid.
Absolutely, Mr. Lüttich. Thank you very much for that submission. I would like to emphasize something that you have just mentioned. In the SAMA, which is the South African Medical Association, in the survey that they did among medical service providers who then said they will no longer treat injured workers, we have to face the fact that if this is the case, if third-party administrators are removed or sessions are prohibited, and because of that, the medical service providers don't want to treat the injured workers any longer because of fear of the problem with cash flow, because they have to wait for the fund and not get pre-funded through sessions of claims by institutions such as your own, then I want to move quickly to the open letter written by the Compensation Fund Commissioner, Mr. Vuyo Mafata, yesterday afternoon, which we received. And what really troubles me is the fact that he says in his letter that they aim to serve the injured worker, that is the most important party that needs to benefit from this value chain. But if the medical service providers now refuse to treat these injured workers, then their rights aren't protected. Those injured workers, they're not being benefited at all. And that's what we're trying to highlight here today, Mr. Lüttich, if I'm right, that if these claims cannot be ceded by the medical service providers, they will no longer treat these workers and the whole value chain will crumble upon itself. And that third-party administrators and refunders are currently the only functional element of this dysfunctional corrupt fund. Am I correct?
That is correct. And more so, he also said that the other role players is as important, and that's the medical service providers. Now, For the life of me, I cannot understand if he makes the statement to say that both the injured workers and the medical service providers are important cogs in this wheel, that he can't see that waiting for 311 days on average for the fund to pay an account is to the benefit of the medical service providers. I mean, as recently as about 3 weeks ago, all of a sudden, they stopped accepting emails as a way of submitting an application for a pre-authorization for a theater booking or a CT scan or an MRI that needs to get done before, let's say, an operation on the injured worker. Just out of the blue, it was stopped. It was replaced by a rule that says you must apply online on the, as we know it now, the dysfunctional CompEasy system. I almost want to call it an abomination that has transpired from that is that they said you can only apply for a pre-authorization once the fund has accepted liability for the claim. Now that sounds very nice and very fair, but that process takes anything between 6 months and 4 years. Now imagine you got injured and you were treated as a casualty. In other words, it was hot trauma and you had to deal with the patient to stabilize the patient. Then you wait, for instance, a brain injury for the swelling to subside in a week or two. And now it's called not an urgent case anymore. So you got to now book and get a pre-authorization so that you can operate on the patient. But if that takes you 4 years, the patient might have passed away before you actually can apply. I'm not saying get the pre-authorization from the fund, apply. That's the thing that drives us up the walls, is to say, how can you lock a system for a medical procedure that is needed because your system does not allow the doctor or the specialist who needs to treat and operate on this patient access to even apply. You cannot apply because the fund has not as yet accepted liability. In the past, we were able to submit because we know it's an IOD. There's a first medical from the first treating physician. There's an ID. There's a first medical report from the employer. So looking at all the data in our possession, we know it's an IOD. It's a question of time. It will be registered and logged as an IOD. So there's no question that that patient must be serviced under the COIDA rules. But now the dysfunctionality of CompEasy does not allow you to access that particular incident because it is not yet adjudicated on and hence accepted by the compensation fund. So just imagine you or your husband or your son that's working that got the serious injury now has to sit and wait for CompEasy for a year before he can get access to the specialist that needs to do a brain operation, for instance, or any other operation for that matter. It's an abomination. It just cannot be. And we have had these discussions up to the highest level. You cannot believe the insanity of the answers that we get back. It is unbelievable.
Absolutely. Thank you, Mr. Lüttich. That is quite devastating to hear. And then it is so ironic, pointing back to the letter of the Compensation Fund Commissioner of yesterday afternoon, in which he states, and I quote, all processes, systems, and laws are aimed at ensuring we serve these parties and that we ease the burden of interacting with the fund by any of the three parties in the legislation and which it is intended to serve. That is quite laughable that should be stated after you have clearly indicated to us just now in how terrible and burdensome these red tape systems are currently.
Correct.
We're going to move on. Mr. Swart, I would like to ask you, after realizing the devastating effect that the prohibition of sessions would have on the industry, on the operationality of employers and on the injured workers, and this entire value chain, what steps did NEASA take to address this issue?
Yeah, thank you, Rona. I think, as already alluded to by previous speakers, everybody was quite puzzled by these amendments and these new rules. There doesn't seem to be any rhyme or reason to them. So what we did is we addressed letters to our constituency. We also issued press releases in this regard, and we also made written representations to the Portfolio Committee in respect of the proposed amendments. Our Chief Executive, Mr. Gerard Papens, was also invited to address the Portfolio Committee on this issue. So our organization joined forces with SAMA and with IWAG in an attempt to convince the powers that be to amend and reconsider these rules. So we will continue to work and campaign to change these rules and to actually campaign against any legislation or rules that impact our members negatively.
Fantastic. Thank you very much, Mr. Swart. Mr. Hughes, what events transpired after the strong reactions and opposition, as Mr. Swart just alluded to, both in written submissions, oral submissions to the Parliamentary Committee, open letters, private letters to the Compensation Fund Commissioner and the Minister of Employment and Labour. What happened after this opposition and the strong reaction from the various role players in the value chain was made public against the implementation of Clause 43, with specific reference to the decisions then by the Parliamentary Committee on that matter? What happened thereafter?
Thanks, Ron. This was democracy in action. This was democracy at its best. This was a situation in which irrational, possibly illegal, unconstitutional efforts, almost through the back door, were blocked by Parliament. They were blocked by the committee. They were blocked because of submissions such as NEASA's, IWAG's, third parties, SAMA. Remember, this is over 80 submissions to Parliament, all of which opposed Clause 43.4, and none of which were in support of 43.4. And at no point did the Minister, the Director General, or the Compensation Fund Commissioner provide reasons or justifications or rationale for 43.4. So overwhelming was the evidence against 43.4. So united were the voices from labour, employers, medical service providers and others against 43.4 that frankly we believe the committee had very little choice but to remove 43.4, which it did. And so democracy worked properly and the clause that you have suggested was inserted in its place. I know we'll discuss what happened thereafter, but notably the bill still had to go up to the National Council of Provinces. And I know we will cast forward to the 11th of September, the day after Parliament rose. So we had really, really good news through our efforts up to that point. And then we had a very significant setback on the 11th of September.
Absolutely. Thank you, Mr. Hughes. On the 11th of September that you're alluding to, the initial banking information requirements notice, the notice in terms of Rule 6, was published in the Government Gazette. Let's talk about that, Mr. Hughes. In summary, what exactly did the rules that you just alluded to on 10 September or 11 September 2021 entail? And why did the various interested parties, including injured workers, employers, medical service providers, and third-party administrators, oppose the implementation of these rules? Just to summarize again, we have now said that the First Amendment Bill was there, and that the destructive Clause 43, which would have seen the whole value chain crumble on itself, was removed by the Parliamentary Committee, and everyone was elated. And like you said, it was democracy in action. And shortly thereafter, the newest rules regarding the account verification system and payment system was then published in the Government Gazette. What did these rules entail, Mr. Hughes? Please explain those rules to us quickly.
Rona, my apologies, 10th of September, you're absolutely right. So you're accurate on the date. Thank you for that. The significant point, it was exactly the day after Parliament rose. And it was still during the period of time where this bill was still in Parliament, had gone through the National Assembly, was at the National Council of Provinces, or was to be referred to the National Council of Provinces. In essence, Rona, the notice on the 10th of September attempted to achieve exactly what 43.4 was attempting to achieve, but really through gazetting. In other words, it was an attempt to bypass the parliamentary process, bypass democracy, bypass accountability, bypass transparency. And if you look at the date in which this notice was drafted, which let's say was 23rd, 24th of August, although published on the 10th of September, the Commission had already prepared this notice while Parliament was still sitting. In other words, he'd ignored what Parliament had determined that he should do, what everyone in the value chain had determined what he should do. And very specifically, although it was couched in fact, very misleading terms in many respects, with no period of discussion or debate, it was simply imposed or published. What that notice sought to achieve was to ensure that only medical service providers would be paid. In other words, the compensation fund will only pay medical service providers. Well, that's exactly what 43.4 was trying to achieve. In other words, he changed the terminology. He didn't use the word session, but effectively what he was trying to do is exactly the same thing. We will only pay medical service providers. And quickly to make that conceptual link, as Mr. Lüttich has done, what he was trying to do was to make sure that medical service providers actually had to wait 311 days on average to get paid without the assistance of third-party administrators. And as you know, there was a very significant pushback against that notice and those regulations, which I'm sure we discussed, because there's a further iteration to what the Commission has been trying to do recently.
Absolutely. Mr. Lüttich, just as Mr. Hughes now said, and I'm confirming this, I'm reading from the first notice, which was gazetted, which states, the compensation fund will no longer accept banking details and nominated bank accounts of agents and other representatives other than that of the medical service provider or healthcare organization which provided the service to the injured or deceased beneficiary. The fund will only accept banking details which belong to the medical service provider or the healthcare organization. In essence, then, Mr. Lüttich, despite the fact that they prohibited sessions and said that sessions would be void with the First Amendment, and the parliamentary committee then removed it, these rules would have had the effect, if they are implemented, to cut out the possibility of sessions completely. Am I correct?
Yeah, you're absolutely 100% correct. It seems to me that what the Commissioner is misinterpreting, or maybe on purpose, is the fact that there's two processes involved here. The first process is one where a third party administers the process of generating the medical account and completing documentation and submitting that to the fund. That is what we call an administrative only process. And he's clear on that the administrative process is not prohibited. The second part of this is the factoring side of the medical accounts. Now, factoring is a legal way of funding any business. It doesn't have to be a medical practice only. It is worldwide accepted norm in obtaining working capital for cash flow purposes. Now, it's very important to note that factoring happens after the service was rendered and the invoice was in fact issued by the medical service provider. We as a third-party funder or a third-party factoring house, we do not create or generate any invoices. An invoice is presented to us. We evaluate the invoice according to the gazetted tariffs and rules. Very easy to do because we know exactly what it should be. And then we make a decision to, yes, this account complies. We will factor this account, and thereafter the funding mechanism starts. There is nothing untoward in doing a factoring transaction. As a matter of fact, we have no control over the services that the medical service providers render, nor the tariffs that they add onto their account. What we will do is, if an account, or rather the tariffs on an account, does not comply, we will so instruct the medical service provider, send the account back and say, please revise, these are the rules if you're in agreement. So as a matter of fact, we actually make sure that any account received by the compensation fund from a medical service provider that treated an IOD patient complies 100% with the gazetted tariffs and the gazetted rules. Now, like I said earlier on, The factoring agreement is a legally binding agreement between us and the service provider. It's got nothing to do with the service that got rendered. That's entirely up to the service provider. The service provider, in terms of the HPCSA rules, can never disengage himself from the treatment that was in fact delivered to the patient. We're only dealing on the factoring side after the fact that the patient was treated and the bill was issued. And what these rules intend to do is to prohibit the funding of a medical practice, whether that's by an overdraft, a factoring arrangement, a loan, or whatever. And in our view, that is unconstitutional to prohibit medical service providers to operate in that way. The reason why it became necessary for doctors or medical service providers to do that is the exact average of 311 days. To add insult to injury, the PE Labour Office, for instance, is 475 days average to pay an account. Johannesburg, which is the largest office, or regional office of the fund, following close on its heels, was 421 days delay before an account gets paid. Now that's the average. So there's some accounts even longer outstanding before they actually get paid.
Okay, thank you very much, Mr. Lüttich. What happened then was these rules were issued, and once again, there was strong opposition, as with the First Amendment, there was strong opposition against the implementation of these rules. The Compensation Fund Commissioner then withdrew these rules. What's funny to note, though, is the dates. The date of the withdrawal of those rules was signed on the 27th of September 2021. The withdrawal notice was signed. On that same day, the notice of the new rules was signed. Shortly thereafter, the new rules, on about 19 October 2021, new rules after the withdrawal of the first detrimental rules were then published in the Government Gazette. Could you please tell us, what did the new rules entail?
Rona, yes, you're quite correct. The deceiving actions is even more clear if you think that we've been in a negotiation process with the fund and its legal team in terms of the first notice, and that we need that notice withdrawn. They agreed to the notice, not with all our terms on it, but they agreed to withdraw the notice. That agreement to withdraw notice 1 was, as you correctly pointed out, was signed on the 27th of September. And the next day we went to court with a draft order that was in fact then made an order of court. The day before we went to court, in other words, the same day he signed the withdrawal, he already signed the second notice, which only was published in October. And the only difference was in the second notice, same content, he only added a 60-day consultation period to the second notice. So everything stayed the same. I think he just thought to comply with some regulation, it's got to be in public domain for comment for 60 days. But nothing has changed from the first notice apart from the 60 days. So although he was negotiating with us, as far as I'm concerned, it was an extremely bad faith by signing the notice while we were still in the negotiations, and he knew we were going to court on the 28th. The second notice was already signed in his own handwriting with the date of 27 September 21.
Thank you, Mr. Lüttich. I believe this is quite the display of bad faith by the commissioner himself. If we look at the notice, the newest notice, it reads, the compensation fund will no longer be accepting banking details and nominated bank accounts of agents. And so it goes on verbatim, the same as the previous rules. Correct. The same day he signed the withdrawal, he also signed the newest rules. And that is very detrimental. And that signs to bad faith from the Compensation Fund Commissioner's side. Mr. Swart, after the Department of Employment and Labour then issued these so-called new rules, which we have now determined determines exactly the same as the old rules, apart from giving the public time to comment thereon, the new rules, which prescribes exactly the same as the previous one. What was NEASA's reaction to this publication in the Gazette of the new rules?
Yeah, thank you. Obviously, we were quite shocked by this. We believed we achieved some sort of victory when that Section 43 was withdrawn or taken out of the Amendment Bill, only to be faced with this backdoor legislation, for want of a better word. Like already mentioned, it's absolutely bad faith. We immediately addressed an open letter to the Compensation Commissioner and to the Minister of Employment and Labour, demanding that these new detrimental rules should be withdrawn. This also culminated in a meeting where a number of interested parties were present, including NEASA, and where we suggested that a workshop should be held in order to determine what the rules should actually look like to be inclusive for all parties.
Absolutely. Thank you, Mr. Swart. That's very true. You just alluded to the meeting that was held by the Compensation Fund and the Minister of Employment and Labour last week on 23 November 2021. This meeting was scheduled with stakeholders such as SAMA, based on an open letter also addressed by SAMA to the Compensation Fund Commissioner and the Minister of Employment and Labour. It also included NEASA and UDWOSA and, of course, IWAG. Mr. Hughes, at this meeting, what exactly was stated by the Compensation Fund Commissioner when he was confronted with, the notion of the fund being against or wanting to prohibit the cession of medical claims? What was his response during this meeting?
Thanks, Rona. And you were present at that meeting, and this is my recordal of it. And on 4 occasions, the minister and the Compensation Fund Commissioner said that they had, quote unquote, no problem with third-party administrators. So whether they were splitting definitional hairs is a moot point, because our contention was that the published notice was critically flawed, and that was the issue we wished to address. So the impression we were left with is that neither the minister nor the Compensation Fund has a problem. So the question then becomes more technical. Then what is it you're trying to achieve? And so we asked the Compensation Fund Commissioner, what is the problem that they are trying to address? Has there been fraud committed? Have you been paying to the wrong accounts? What it is you're trying to achieve with these account verification system? And we asked him very, very specific questions. At no point did the commissioner reply on any specifics to any question raised at that point, none whatsoever, which he discussed and debated issues about process and background and the like, but he at no point provided any justification in front of anybody in that meeting for that notice, none whatsoever, which left us, in my words, perplexed. And I said that to the minister as well. You correctly referenced the fact that the minister took the initiative during the course of this meeting in repeating the mantra that the department and the Compensation Fund has no issue and no problem with third-party administrators. And remember, at that meeting were heads of the Compensation Fund in most of the provinces, legal advisors, technical advisors, IT advisors, etc., including the minister's own PA in that particular meeting. And it was the minister that seized the moment to say, let's put together a technical team. And I will repeat what the minister said at that meeting. Number 1, we do not want any deadlock. Number 2, we do not want litigation. Number 3, we do not want any constitutional challenge. Number 4, we have to achieve an outcome through negotiation. And that was the basis of the formation of this particular task team as well. And more specifically, if I may, Rona, what was very interesting about that as well, which was very encouraging to us, is remember when we'll discuss at the end that the period for public commentary ends, let us say, on the 18th or the 19th of December, which is a difficult time. But remember too, and you will recall that the minister was very specific in calling for this task team with legal representation to meet before the 19th of December. And that was his very specific mandate, which was agreed to by the commissioner and all parties to the meeting.
That's true. Tim, thank you very much for that. I was present at that meeting, and I can concur with what you said transpired during this meeting. You've just mentioned that, yes, the minister instructed the compensation fund to meet with the stakeholders, as Mr. Swart said, to discuss the rules and what would be better, what would benefit all the stakeholders, and ultimately, what would be best for the injured workers, what would get them treated effectively, efficiently, what would speed up the claims process. We need to design rules that would benefit the stakeholders of this value chain, first of all, the injured workers and everyone along with that. Now, this task team seems like a great initiative and instruction from the minister himself. However, have you had any interaction from the fund, from their side, to schedule this meeting, to schedule this workshop on the rules? Or have we just been given the 60 days to deliver public comment on the rules as is?
Yes, that's critical point now, Ronan. That is to say, to to make this thing happen. And so we have asked for 3 dates, 2 to 3 dates from the compensation fund to meet. We will be open, we'll be flexible. If they provide us with those 2 to 3 dates, we will meet with them, with both sides, to get this task team working and to come to a resolution of these issues before the 19th of December, hopefully. We have not received any initiative, any feedback, or any dates from the compensation fund to date.
Thank you very much, Mr. Hughes. NEASA will keep employers and the industry abreast of any developments in this regard should we receive any confirmation of available dates from the compensation fund side for this purpose. I want to refer once again, and we're almost at the end of this panel discussion, to the open letter by the Compensation Fund Commissioner, where he said, and as Mr. Hughes alluded to the fact that he confirmed this 4 times during the meeting, I should reiterate what we have always said: the fund is not opposed to any healthcare provider using a third party to assist with the administration of its claims against the fund. But the practice should not result in the rights of other parties in the claims process being violated. I just want to ask you, Mr. Lüttich, what could the Compensation Fund Commissioner mean with this? If we have just established through today's panel discussion that the use of third-party administrators benefit the injured worker of getting treated speedily by a medical service provider who is now willing to treat him because they know either through the factoring or the pre-funding or the administration of the claim, they will be assisted by the third-party administrators. And the employer then gets their employee back and doesn't experience, excessive operational problems with the injured worker not being treated speedily or the claim not being paid. Whose rights are being violated, as mentioned by the Commissioner? What in this practice of the use of third-party administrators, who will be violated?
You are as perplexed as what we are in terms of that statement. If I can just go back to the process. The whole process is supported by an infrastructure, and that infrastructure consists of the employers who needs to report the accident, the medical service providers, whoever they might be in terms of disciplines, and then the administrative process that follows the treatment. That needs to work as a cohesion, as one group. And what we're trying to do with the software that we've rolled out to our more than 1,300 different practices throughout the country is a consistent way of operating in the treatment of injury on duty patients that complies 100% with the legal requirements of the Act. So as far as that's concerned, there's no body that is, or nothing that in that process is detrimental to anybody in the process. In other words, the injured employee has got access to the best medical care in South Africa, in the best hospitals available in South Africa, and in the most efficient administrative system and processes in South Africa. So given all of that, that complies with the gazetted rules and regulations, we're now faced with a simple post the treatment, post the issuing of an invoice fact of factoring. It's like most practitioners probably seed their total debtors book to a bank to get an overdraft. This is just a different way of financing your working process. In other words, you factor your IOD part of your debtors book to get faster cash flow. Like I said earlier on, you can't wait for 400 days in the case of Port Elizabeth and Johannesburg offices to get paid. No doctor is going to be able to carry his staff, his rent, his expenses, all the prosthesis that he has to pay for to assist patients when he operates on them. It's unreasonable to expect they must accept these type of delays. That's where we come into the party. And we work 100% according to rules and regulations that are gazetted. There's unambiguous ways this is how it's going to happen. And what we then say is there's no cost to the fund, there's no cost to the employer, there's no cost to the employee, and more than what the gazetted tariffs are. In other words, the medical service providers treating the injured patients are giving away part of their gazetted income to assist, for us to assist them in this whole complex process and to get the cash flow into their practices. So we cannot see any problem in terms of or any legal obstacle or legal problem that we are causing in the whole process. What we can see is that because we can act on behalf of 1,300 service providers collectively, we can very easily afford to take legal action against the fund that is not acting in terms of the legislation that they are supposed to do. Their system called CompEasy is inadequate. They're faced with, I think, 10 years in a row of the Auditor General qualified audit reports, and they want to shift blame and shift the focus away from them to something that is manufactured, to something that does not exist. The fact that a practice wants to factor his accounts has got nothing to do with the service delivery, the treatment of the patient. As a matter of fact, without that, the patients will have to fall back into the public health. And that is a major and a bigger problem, because there is no budget, they haven't got an allocation, they haven't got the manpower, they cannot treat this volume of injury on duty cases. And over and above that, the Act is very clear. A patient has a free choice, an injured worker has a free choice where to go for medical treatment when an IOD or an injury on duty occurs. So by doing that, you're actually taking away the right from an injured employee to go see the doctor of his choice, to go to the hospital of his choice, and for the doctor after treatment to do with his accounts on a financial level as he sees fits. In other words, he's trying to prohibit the financial functionality of all the medical practices that's currently treating IODs.
Yes.
So no, we can't see the rationale for that.
Thank you, Mr. Lüttich. I completely agree with you. And it's funny that you mentioned that you are almost the only stakeholder in this value chain, which has the ability, the time, the administration, the power, and the funds to take the fund to court should they be acting against the Act. Mr. Swart, as the national manager of NEASA, the Employers Association, could you speak to the fact that the minister might have a sinister intention with these rules and cutting out the third-party administrators who seem to be the only ones who have the power to hold them to account in the courts?
Yeah, Rona, obviously it would be speculation, but as mentioned already, there seems to be no logical reason for these rules, and we can only speculate that they are trying to cut out third-party administrators because they will be exposed. Your normal medical service providers do not have the funds or the ability to possibly navigate the system at all, and blame can be shifted easily to them to say, well, you're doing something wrong, while the problem is at the fund administration itself. So I think, like we mentioned, it's a blame-shifting exercise, and I think they're trying to protect themselves to hide their own dysfunctionality and inefficiencies.
Okay. Thank you very much, Mr. Swart. That's very true. Although we can only speculate, I would say that the timelines and the lack of rationale behind these rules speak for themselves. To conclude this meeting, let's just refer back to that open letter of the Compensation Fund Commissioner, which in which he says, finally, the portrayal of the fund as dysfunctional could not be further from the truth. While it has not reached the desired level of efficiency, we are seeing the fruits of the turnaround strategy adopted 5 years ago. This is ironic to me if we look at what was, or the events that transpired during the SCOPA hearing, which is the Parliament's public finance watchdog, in which they scolded the commissioner and even instructed the minister to conduct a full investigation into the fund and its dysfunctionality, the allegations of corruption, and furthermore, the wasteful and fruitless expenditure that has been noted by the Auditor General in the books of the fund. It's funny that the SCOPA chair then instructed the Minister of Employment and Labour to even furthermore conduct a performance assessment on his Director General, Tobile Lamati, and the Compensation Fund Commissioner, Vuyo Mafata, to establish their respective fitness to hold office. We are to see, hopefully soon, the results of these investigations, the plans that the fund has to better their service delivery. But NEASA would like to now have a call to action to the public out there as well, and any of the stakeholders and people who might be affected hereby. And like Mr. Hughes said, it might be you working, it might be you as employer, it may be the worker itself, as well as the third-party administrators and any other financial institutions, as well as the stakeholders of IWAG. NEASA herewith therefore calls on all affected and interested parties to submit your inputs and your public commentary via the following channels. You can submit your written comments in writing by mail to the Compensation Commissioner at PO Box 955, Pretoria 0001, or via email at commentsavs@labour.gov.za. We will be sending out a press release regarding this panel discussion, in which there will be a link to this panel discussion for the interested parties. I want to thank you once again, the panelists. Mr. Lüttich from Compsol, thank you very much for your inputs today. It was very valuable understanding how the system works and where it doesn't work from the compensation fund side, and the valuable role that third-party administrators and pre-funders play in this value chain in this industry. Mr. Hughes, thank you very much for your participation today, and as the voice of the injured workers out there who ultimately need to benefit from a functional compensation fund, whether or not it be with the assistance of the third-party administrators. Thank you very much, Mr. Swart, as the voice of employers and highlighting the importance of holding all of these state departments and funds to account for their actions and for any dysfunctionality. Thank you very much for attending today's panel discussion.
Thank you for hosting us, Rana. Appreciate it.
Thank you to you and NEASA. Much appreciated.
Thank you very much. We look forward to the scheduling of the meeting with the Compensation Fund in order to rewrite these rules in order to benefit this industry. Thank you and goodbye.